Hello and welcome to BYJU'S Exam Prep. Today is the last lecture on Indian polity. We have had 3 lectures on Indian polity. Today is the 4th and the last one. But the Target Prelims 2022 crash course continues. The next 2 live sessions will be on various government schemes and programs. Then we will have 3 back-to-back live sessions on environment and ecology. Then we will have 2 remaining sessions on Indian economy. We have had 2 sessions on Indian economy previously. Then we will have 2 more sessions, followed by 3 live lectures on science and technology. Then we will have 1 special lecture on various reports and the indices. And then the final 2 lectures on May 20 and 21 will be on international relations. So today is the last lecture on Indian polity. I'm going to miss you. But before we start, press the like button, comment once the video is over, subscribe to our channel if you haven't yet, and share the links of these live classes with your friends and fellow aspirants. Let's get started and look at the office of the President of India. Because I told you, President's office and the Vice President's office is going to be very important for this year's prelims examination. Why? Because we have had elections to the office of the President and the Vice President last time in 2017. And now, this year, we are going to have elections to the office of the President and the Vice President. That makes these 2 offices most important so far as your prelims examination is concerned. When we look at the Constitution of India, it says under Article 52 that there shall be a President of India. And this word shall makes it clear that our constitutional scheme cannot be imagined to function even for a brief moment without somebody occupying the post of the President of India. So there shall be a President of India means that this office can never remain vacant. Someone has to occupy this post at all times. And Article 53 of the Constitution, it says all the executive powers shall be vested with the President of India. But that doesn't mean that President is the most powerful institution in India. We have to look at Article 52 and 53 in association with Article 74. And Article 74 says, there shall be Council of Ministers with Prime Minister at its head to aid and advise the President. This was the only phrase mentioned in the Constitution. Constitution only talked about there shall be Council of Ministers with Prime Minister at its head to aid and advise the President. That's it. But then the year was 1976 when 42nd Constitutional Amendment Act was passed and another phrase was added to Article 74. And this phrase was, who shall act on the advice? That means there shall be Council of Ministers with Prime Minister at its head to aid and advise the President, who shall act on that advice. So it is this 1976 amendment which made it binding on the President to accept any advice that is given to him by the Council of Ministers headed by the Prime Minister. 2 years later, 44th Constitutional Amendment Act in 1978, it added few more lines. Provided the President may ask for reconsideration of that advice. But whatever advice is re-tendered to the President, that becomes binding on the President of India. So we have had 2 very important amendments of far-reaching consequences vis-a-vis the office of President when it deals with Article 74. And any advice of the Prime Minister and his Council of Ministers is binding on the President of India. President may only ask for reconsideration, that too only once. But whatever advice is re-tendered, that becomes binding on the President of India. So far as the qualification is concerned, Constitution says that there are few qualifications required for someone in order to contest the election to the post of the President of India. What are these qualifications? This person shall be the citizen of India. This person shall have completed 35 years of age. This person should be eligible to become a member of Lok Sabha, and at the same time, this person should not be holding any office of profit. That means a citizen of India who has completed 35 years of age, who is eligible to become a member of Lok Sabha and who is not holding any office of profit, this person is qualified to get elected or to contest election to the office of the President of India. And who conducts this election? The responsibility is with Election Commission of India. But the President of India is elected in an indirect fashion. Is the President of India elected by the people? Yes. Is the President of India elected by the people? Yes. But indirectly elected by the people through their representatives in the Electoral College. And this Electoral College becomes very important for this year's examination, and I will tell you why. Electoral College consists of elected members of both Rajya Sabha and Lok Sabha, elected members of the state legislative assemblies, but not only of the state legislative assemblies, including the legislative assemblies of Delhi and Puducherry. Why? Because Delhi and Puducherry, these are the two union territories which have legislative assemblies as well. But what about Jammu and Kashmir? That is why it becomes important for this year's prelims examination. The year was 2019. Jammu and Kashmir was reorganized and bifurcated into union territories. Union territory of Jammu and Kashmir, Union territory of Ladakh. Jammu and Kashmir is going to have a legislative assembly. Right now they don't have. But Ladakh is a union territory without any legislative assembly. But if the legislative assembly members, elected MLAs of Delhi and Puducherry, are going to participate in the election of the President of India, what about the MLAs of Jammu and Kashmir Legislative Assembly? We will also discuss today the delimitation exercise, which has now been completed for the Union Territory of Jammu and Kashmir. And in all likelihood, there shall be elections to the Legislative Assembly of Jammu and Kashmir very soon. But I don't think this election would be conducted before July, when we have the election to the office of the President of India. But even if we have a legislative assembly in Jammu and Kashmir, can these elected MLAs of Jammu and Kashmir Legislative Assembly participate in the election of the President of India? In a sense, are they also part of the Electoral College? We have no clarity. Why? An RTI application was filed. Election Commission of India gave a reply to this RTI application recently. But in that reply, the Election Commission of India was not very clear in its response as to whether Jammu and Kashmir MLAs, once they are elected, whether they will become part of the Electoral College to elect the President of India or not. The simple reply given by Election Commission was, please go through the provisions of the Constitution. It is mentioned who is part of the Electoral College. But so far as prelims examination is concerned, we need to include some very important detail. Whenever there is a change, or whenever we want to change the provisions regarding the election of the President of India, regarding the manner and the method of presidential election, that requires a constitutional amendment under Article 368 of the Constitution. But not a simple constitutional amendment. This constitutional amendment needs ratification by half of the states as well. So Constitution, if you have to amend some of the federal features of the Constitution, for that a constitutional amendment bill should be passed by both houses of the Indian Parliament, that too by special majority. But if this Constitutional Amendment Act wants to change, alter, amend some of the federal features of the Constitution, for that you need ratification by more than half of the states as well, And one of the federal feature is if you want to change the manner and method of president's election. Which means if you want to include the MLAs of Jammu and Kashmir to Electoral College as well, to elect the President of India, you need a constitutional amendment passed by both houses of the Parliament, and at the same time you need ratification by half of the states as well. And this is exactly how it was done when Delhi and Puducherry MLAs 70th Constitutional Amendment Act was passed, and through this 70th Constitutional Amendment Act, the MLAs, the elected MLAs of Delhi and Puducherry became part of the Electoral College to elect the President of India. So if J&K MLAs are also to be included in the Electoral College, one explanation is that you need to amend the Constitution using Article 368 and get this constitutional amendment bill ratified by half of the states as well. But there is another set of constitutional experts, for example, Mr. P.D.T. Achari, who was once the Secretary General of Lok Sabha. He said that according to Jammu and Kashmir Reorganization Act of 2019, whatever provisions are there for Puducherry, those provisions are there for Jammu and Kashmir as well. So if Puducherry MLAs are part of the Electoral College, J&K MLAs will also be part of the Electoral College. But there is another very strong view by some constitutional experts who say no, since Jammu and Kashmir Reorganization Act was passed by an ordinary law, it was an ordinary law passed by simple majority, you cannot change the constitution through an ordinary law. For that you need to pass a constitutional amendment bill, and that too get ratified by half of the states as well. That is to be done if you want to include J&K MLAs as part of the Electoral College. So the President is elected by the people of this country, but not directly, indirectly. Indirectly through their representatives. And where are these representatives? In the Electoral College. And what is the Electoral College's composition? Electoral College consists of elected members of Rajya Sabha and Lok Sabha, not the nominated members. Elected members of State Legislative Assembly, including Delhi and Puducherry. And at the same time, President is elected through a system called proportional representation system by means of single transferable vote through secret ballot. We don't have to explain what is this proportional representation system because that is going to take a lot of time, but you just need to keep in mind for the prelims exam that President is not elected through first past the post system, because first past the post system we use for Lok Sabha election, for Legislative Assembly election, but so far as the President is concerned, Vice President is concerned, Rajya Sabha MPs are concerned, Legislative Council MLCs are concerned, we use what is called proportional representation system. That too by means of single transferable vote, which means here you will have to give preferences. So if there are 4 candidates contesting the election, these members of the Electoral College may give preferences. My first preference is A, my second preference is D, my third preference is B, so on and so forth. But, very important point for your prelims, it is not necessary to give all these preferences. A member of the Electoral College may give only first preference without giving second, third, fourth or fifth preference. But first preference, he or she will have to give, otherwise the vote will be invalid. And at the same time, election takes place through secret ballot. That means while casting your vote, as the member of the Electoral College, you don't have to reveal your preference. If you reveal your preference, your vote will be declared invalid. And when the election is through secret ballot, there are 2 more things that you have to keep in mind. Thing number 1, electronic voting machines are not used. Ballot boxes are used, ballot papers are used. And at the same time, the whip issued by the political party will have no meaning whatsoever. That means no whip can be issued by the political parties that you have to vote in favor of candidate A or candidate B, which means the members of the Electoral College will have to vote based on their conscience. They shall not be bound by the whip issued by the political party. That is something that you have to keep in mind. So this is how the President of India is elected to his office. And after the election, the President will have to subscribe to an oath or the affirmation. And this oath or affirmation is administered by the Chief Justice of India. If Chief Justice of the Supreme Court is not available, then by any senior most member of the Supreme Court. And this oath is very important because President of India takes the oath to defend the Constitution. What makes the oath of the President very unique is that the President takes the oath to defend the Constitution. Other constitutional functionaries, they take the oath to faithfully discharge the duties of the office about which they are about to enter. But so far as the President is concerned, he or she takes an oath to defend the Constitution. And any dispute that there can be vis-a-vis the election of the President of India, that case, election dispute case, can be filed only in the Supreme Court, whose decision shall be final and binding. Because last time, when we had an election to the office of the President, when Mr. Pranab Mukherjee was the candidate and Mr. P.S. Sangma was the other candidate, there was a dispute vis-a-vis this election of the President. The dispute was that Mr. P.S. Sangma alleged that Pranab Mukherjee is holding an office of profit, and that is why he should not be allowed to continue as the President of India. But this petition was dismissed by the Supreme Court because such a case, whenever there is a case involving the dispute to the election of the President, that dispute can be filed, that election petition can be filed only in the Supreme Court, and the decision of the Supreme Court shall be final and binding. Now let's look at the question. Consider the following statements. The notification calling the election to the office of the President can be issued by the Election Commission on any day within the period of 60 days before the expiry of the term of the office of the outgoing President, which means we can expect the election notification anytime in the future weeks, because the office of the President, once it falls vacant in July, prior to that, within 60 days, the election notification should be issued by the Election Commission of India. Statement number 2, for the presidential election, the Secretary General of Lok Sabha is always the returning officer. Who is the returning officer when it comes to the office of the President of India or the election of the President of India? It is not always the Secretary General of Lok Sabha. Sometimes it is Secretary General of Lok Sabha, then it is the Secretary General of Rajya Sabha. That means by rotation, we will have Secretary General of Lok Sabha for one election, Secretary General of Rajya Sabha for another election, for next election as the returning officer. 2017, when the President's election was conducted, it was the Secretary General of Lok Sabha who was the returning officer. So for this year's presidential election, it's going to be the Secretary General of Rajya Sabha who is going to be the returning officer. That means through rotation, they act as the returning officers. So which of the above statements are correct? A, only one is the right answer. Let's look at another question. Consider the following statements. Members of the Electoral College can vote according to their wish and are not bound by any party whips. When the voting takes place through secret ballot, which means you are voting through your conscience based on your wish, that means the whip of the political party is not binding on you, which means statement 1 is correct. Statement 2, an elector under preventive detention is ineligible to cast his or her vote. Who is an elector? Somebody who is part of the Electoral College, which means the member of Lok Sabha or Rajya Sabha, elected member, or elected member of the State Legislative Assembly, or we will have the elected MLAs of Delhi and Puducherry. If one MLA or an MP is under preventive detention, does that mean he or she is ineligible to cast his or her vote? No, this is incorrect. Those electors who are in preventive detention, they can cast their vote through postal ballot. That means they are still eligible to cast their vote. So statement 2 is incorrect. The question is asking which of the above statements is or are correct. Only one, A, is the right answer. Let's look at the office of the Vice President of India. Constitution says there shall be a Vice President And the role of the vice president, he or she performs a dual role. One, he or she is the ex officio chairperson of Rajya Sabha. That means by virtue of Mr. Venkaiah Naidu holding the office of the Vice President of India, by virtue of that office, he is also the chairperson of Rajya Sabha. But Vice President, very important point, is not a member of Rajya Sabha. Despite the fact he is not a member of the Rajya Sabha, but he presides over Rajya Sabha as the chairperson of Rajya Sabha by virtue of him holding the office of the Vice President, which means Vice President is the ex officio chairperson of Rajya Sabha. That is role number one. And role number two is he acts as the President of India whenever there is a vacancy in the office of the President of India. But for how long? And this is where it becomes even more important. We have the office of the Vice President of India modeled to a very close extent on the lines of the Vice President of the United States. Kamala Harris, Ms. Kamala Harris is the Vice President of the United States. What if tomorrow the President of the United States, Joe Biden, dies? Vice President of the United States will automatically become the President of the United States. But for how long? For how many years? How many months? For the remainder of the term. Which means if the term of the President of the United States is 4 years and Joe Biden dies after a year, then Kamala Harris will become the President of the United States for the remainder of the term, which is 3 years. But that's not the case with respect to India. If the President of India dies, or he resigns, or he is impeached from his office, that means there is a vacancy. The Vice President will act as the President of India till the President or the next President is elected, and should be elected within 6 months. That means whenever there arises a vacancy in the office of the President of India, then what happens? Vice President will act as the President of India. But for how long? Not for the remainder of the session, but only till the next President is elected, which should be done within 6 months. There is a lot of talk regarding the health condition of US President Joe Biden. Some say that he may not continue the entire term of 4 years because he is suffering from various ailments, whether right or wrong, whether fake news or not, we don't know. But since this is in news, that is why this becomes relevant for your examination. Clear? And Vice President is also elected by the people, but not directly, indirectly. Indirectly, through their representatives in the Electoral College. But the Electoral College of Vice President's election and the President's election differ. The Electoral College of the President consists of elected members of both houses of the Parliament, elected members of the state legislative assemblies, elected members of Delhi and Puducherry. But so far as the Electoral College of the Vice President is concerned, it consists of members of both houses of the Parliament. And when we say members of both houses of the Parliament, it includes elected as well as nominated members. But another interesting thing regarding the office of the Vice President is that Vice President can also be removed from his office, just like President can be removed from his office. But the term that we use for President's removal is impeachment. And impeachment is the term used only and only for the President of India. But on what grounds can the President of India be impeached? The grounds mentioned in the Constitution are violation of the Constitution. But there are no grounds mentioned in the Constitution that are mentioned for the removal of the Vice President. That means President can be impeached on the grounds of violation of the Constitution. But on what grounds can the Vice President of India be removed from his office? These grounds are not mentioned in the Constitution. But for the removal of the Vice President, under Article 67 Clause B, this is one of the special power of Rajya Sabha. That means to remove the Vice President from his office, this proposal can be initiated only in the Rajya Sabha. Lok Sabha has a special power. Money bill can be introduced only in Lok Sabha. Financial bill can be introduced only in Lok Sabha. Similarly, there is a special power available with Rajya Sabha, which is if you want to remove the Vice President from the office, this proposal must be initiated only in Rajya Sabha. And if Rajya Sabha passes this resolution by effective majority, then this resolution is sent to Lok Sabha. And once Lok Sabha approves this resolution by simple majority, then Vice President is removed from his office. So Vice President of India can be removed from his office, although the grounds for removal are not mentioned in the Constitution, but the procedure is. The procedure calling for the removal of the Vice President shall be initiated, or the proposal or the resolution shall be initiated only in the Rajya Sabha. And once this resolution is passed by effective majority, then it is sent to Lok Sabha. If Lok Sabha also passes this by simple majority, then the Vice President is removed from his office. Another important point, I told you that there has to be someone occupying the post of the President of India at all times. That means our constitutional scheme cannot be envisaged to function even for a brief moment without somebody occupying the post of the President of India. So what if there is a vacancy in the office of the President? Who will act as the President of India? Vice President. What if there is a vacancy in the office of the Vice President as well? Who will act as the President of India? Constitution was silent on this. Constitution did not mention anything vis-a-vis this scenario. And this is when in 1969, when President Zakir Hussain died, suddenly died, then V.V. Giri became the acting President of India. Then he also wanted to resign because he wanted to contest the President's election. During this period, a law was passed called President Discharge of Functions Act 1969. And it is this President Discharge of Functions Act 1969 which says that if there is a vacancy in the office of the President, Vice President will act as the President of India. If there is a vacancy in the office of the Vice President as well, then Chief Justice of India will act as the President of India. If there is a vacancy in the office of the Chief Justice as well, then any senior most judge of the Supreme Court shall act as the President of India. That means Chief Justice of India can also act as the President of India. This is not mentioned in the Constitution. A senior judge can act as the President of India. This is not mentioned in the Constitution. Where is it mentioned? It's mentioned in a law called President Discharge of Functions Act 1969. And when a Chief Justice of India acts as the President of India, he cannot continue as the Chief Justice of India. That means he can hold office only of the President of India. Someone else will be the Chief Justice of India. But let's imagine a situation. President office is vacant. Vice President office is vacant. We have a Chief Justice whose term is till he or she attains the age of 65. That's the retirement age. What if the Chief Justice of India, his term is for 3 years, or he is going to continue for 3 more years? His age is 62. Now he will act as the President of India. And within 6 months, there should be election to the office of the President. After that, where is this Chief Justice going to go? Where is this acting President going to go? Because now we have a next President who is elected for the next 5 years. This acting President will go back as the Chief Justice of India. And this has happened once. But that is something which is not mentioned in the Constitution. That is something which is mentioned in President Discharge of Functions Act 1969. Another important point. When it comes to the impeachment of the President of India, the members of legislative assemblies of states, they do not participate. When it comes to the election of the President of India, the nominated members of Rajya Sabha, they do not participate in the election of the President of India. But these nominated members of Rajya Sabha, they participate in the impeachment process of the President. So I, as a nominated member, I don't have right to vote in a presidential election, but I have the right to vote when we have to impeach the President from his office on the grounds of violation of the Constitution. Now let's look at the questions. Consider the following statements. The Electoral College to elect a person to the office of the Vice President consists of all the elected members of both houses of the Parliament. The Electoral College to elect a person to the office of the Vice President consists of all the elected members of both houses of the Parliament. Is this correct or incorrect? There is a confusion now in your mind. You might want to say this statement is incorrect. This statement is correct. Sir, no. Nominated members also participate in the election of the Vice President of India? Yes. If the statement would have mentioned, and please listen to me carefully, this is where some people make mistakes, some aspirants make mistakes. If the statement was, the Electoral College to elect a person to the office of the Vice President consists of only the elected members of both houses of the Parliament, then the statement was incorrect. It is saying that it consists of all the elected members. It doesn't say that nominated members are not part of it. It only says elected members are part of it. All the elected members are part of it, which means the statement is correct. If it was saying only the elected members, then the statement is wrong. Because even the nominated members of Rajya Sabha, they are part of the Electoral College to elect the Vice President to his office. So statement 1 is correct. Statement 2, the returning officer for the Vice Presidential elections is the Secretary General of Rajya Sabha, as Vice President is the chairperson of Rajya Sabha. This is some sort of an explanation given that Vice President of India is the ex officio chairperson of Rajya Sabha. Since this is correct, that means there UPSC is trying to confuse you. Confuse you by saying that since sowing some seeds of discord, sowing some seeds of confusion in your mind, that yes, since Vice President is the ex officio chairperson of Rajya Sabha, Vice President deals only with Rajya Sabha, maybe only the returning office, only the Secretary General of Rajya Sabha would be the returning officer. But this statement is incorrect. Just like President's election, for Vice President's election also, the returning officer is the Secretary General of Lok Sabha and the Secretary General of Rajya Sabha by rotation. That means for one election, it will be the Secretary General of Lok Sabha. For the next election, it can be the Secretary General of Rajya Sabha. So this statement is incorrect. So which of the above statements is or are correct? Only one, A, is the right answer. Clear? Now let's look at another question. While the Speaker of the Lok Sabha enjoys a casting vote in the case of equality of votes, the Chairman of Rajya Sabha does not, as he is not a member of Rajya Sabha. Whenever a bill is to be passed in the Parliament, let's say Lok Sabha or Rajya Sabha, and on this particular bill there is a deadlock, some sort of a deadlock. And what is this deadlock? Equal number of people are in favor of this bill, equal number of members are against this bill. That means there is a tie. When there is a tie, when there is an equality of vote, as the presiding officer, I am the Speaker of Lok Sabha, I have the casting vote. That means I can either vote in favor of this bill or I can vote against this bill. But Speaker, he does not vote in the first instance, which means when the bill is being presented to the House of Lok Sabha, voting takes place. In the first instance, as the Speaker, I do not vote. But when there is an equality of votes, when there is a tie, I have the casting vote. That means I can vote either in favor of the bill or against, just to resolve this deadlock. And the same power is given to Rajya Sabha chairperson as well. Rajya Sabha chairperson also, he is not a member of the Rajya Sabha, but he has a casting vote whenever there is an equality of votes. So this statement, while the Speaker of Lok Sabha enjoys a casting vote in case of equality of votes, the chairman does not, as he is not a member of Rajya Sabha, this statement is incorrect. According to the Constitution, if there is a vacancy in the office of the President and the Vice President, the Chief Justice of the Supreme Court shall act as the President of India. Is this statement correct? This statement is half correct, but it is not mentioned in the Constitution. I told you this is mentioned in President Discharge of Functions Act 1969. It is this act which creates possibilities. Vacancy in the office of the President, Vice President may act as the President of India. Vacancy there as well, then Chief Justice of the Supreme Court. If not, then a senior judge of the Supreme Court. But this is not mentioned in the Constitution. So this statement is also incorrect. The question is asking, which of the above statements is or are correct? Neither 1 nor 2, D, none of the above is the right answer. Clear? Let's look at another question with reference to election symbols. The poor guy, Mr. Chirag Paswan, unfortunately lost his father, who was the Union Minister, Mr. Paswan, Ramvilas Paswan, who was also known as the political weathercock. In a sense, he would see in which way the political winds are flowing and he will join that group. But be that as it may, he lost his father. But then there was a coup. There was a political coup in his party. There were 5 MPs in Lok Sabha from the party of Mr. Paswan called Lok Jan Shakti Party. 4 of the other MPs, they rebelled against Chirag Paswan. This rebellion was led by the uncle of Chirag Paswan. And they said that now the uncle of Chirag Paswan is the real leader of Lok Jan Shakti Party. And in fact, his uncle was also appointed as a union minister under Mr. Modi's cabinet. Mr. Chirag Paswan said, I head the real Lok Jan Shakti Party. His uncle is saying, I head the real Lok Jan Shakti Party. In this case, there is now a dispute. And the dispute is not only on the party, the dispute is also on the symbol, election symbol. That is why when there were by-elections to Bihar Legislative Assembly, both the factions of Lok Jan Shakti Party, they could not use the party symbol because this party symbol was frozen by the Election Commission of India. Election Commission of India will now decide who heads the real faction, who heads the real Lok Jan Shakti Party. And once Election Commission decides who is the real Lok Jan Shakti Party, whether the camp led by Chirag Paswan or the camp led by his uncle, only then can this doubt be resolved. So it is in this backdrop that I picked up this question. So what is the question? Consider the following statements with reference to election symbols. No 2 political parties can have the same election symbol. What do you think? Right or wrong? Right or wrong? I'll give you 10 seconds to make up your mind. No 2 political parties can have the same election symbol. This is incorrect. What is the symbol of the Samajwadi Party? Cycle. What is the symbol of Telugu Desam Party led by N. Chandrababu Naidu? Cycle. What is the symbol of the Panthers Party which was created by Professor Bhim Singh? Cycle. So 2 political parties can have the same symbol as well. But no 2 national political parties will have the same symbol. No 2 state political parties in a state will have the same election symbol. Which means if Samajwadi Party wants to contest election in Andhra Pradesh, they cannot use the cycle symbol. They have to choose some other symbol. Why? Because in that state, Chandrababu Naidu's Telugu Desam Party, which is a state political party in Andhra Pradesh, and they are using their symbol as cycle. That means Samajwadi Party will have to choose another symbol. And same goes if Chandrababu Naidu decides to contest election in Uttar Pradesh. They cannot use the election symbol as cycle because that is going to confuse the voters. They will have to choose a different symbol because they are not a state political party, a recognized state political party in Uttar Pradesh. So this statement, no 2 political parties can have the same election symbol, is incorrect because 2 political parties can have same election symbol. But if you are a recognized political party in a state, 2 political parties cannot have same election symbol. 2 political parties at the national level cannot have the same election symbol. So this statement is incorrect. 2, after a split in a political party, The Supreme Court has the power to decide which faction of a political party gets to use the allotted symbol. Not the Supreme Court, it is the Election Commission of India which gets to decide on this question. And this controversy was in the news also a few years ago when there was a split in AIADMK, which was led by the deceased J. Jayalalitha after her demise. There was a split in the political party. One faction was led by Mr. Palaniswamy, the other faction was led by Mr. Paneerselvam, and then the symbol of AIADMK, the two leaves symbol of AIADMK was also frozen. But it's not the Supreme Court, it's the Election Commission of India which gets to decide on this question. So which of the statements given above is or are correct? None of the statements are correct. D, neither 1 nor 2 is the right answer. Clear? Let's look at another question. Which of the following statements is or are correct regarding the National Legal Services Authority or NLSA? This National Legal Services Authority, it has been given a status based on the Legal Services Authorities Act of 1986-87, and the purpose of this law is to allow the disputes to be resolved through arbitration, through mediation, through conciliation. Let's look at some of the questions, some of the statements regarding this question. Statement number 1. The Chief Justice of India is the Executive Chairman of NLSA. This statement is wrong. Why? Because it's the Senior Judge of a Supreme Court, not the Chief Justice of India, who is the Executive Chairman of this authority. Statement 2. The administrative expenses of the authority, including the salaries, allowances and pensions and other employees, shall be defrayed out of the Consolidated Fund of India. This statement is correct. The function of the authority is to encourage the settlement of disputes by way of negotiation, arbitration, conciliation. This statement is correct. Select the correct option from below. So 2 and 3 are correct. C is the right answer. Now this is where some of you may be confused. Statement 2 talks about the salaries are defrayed out of Consolidated Fund of India. That doesn't mean the salaries are charged on the Consolidated Fund of India. Whenever there is an expense which is charged on the Consolidated Fund of India, Lok Sabha has no right to vote on those expenses. Parliament can only discuss those expenses, but Lok Sabha cannot vote on these expenses. But here we are talking about the expenditure is going to come out of Consolidated Fund of India. That means only once the Parliament approves, then you can withdraw money so as to pay salaries and allowances and pensions to the members of this authority. So it is not charged expenditure, it is expenditure made on the Consolidated Fund of India. Clear? Again, so far as these funds are concerned, we have Consolidated Fund of India, we have Public Account of India, and there is another fund called Contingency Fund of India. Article 266 of the Constitution, it talks about Consolidated Fund of India, it talks about Public Account of India. Almost the entire investment raised, taxes generated, revenue generated by the central government, they get deposited in this Consolidated Fund of India. And this Consolidated Fund of India, Parliament exercises control. That means without the approval of the Parliament, no money can be withdrawn from the Consolidated Fund of India. That means this Consolidated Fund of India is operated through a legislative action. Without parliamentary law, the government of the day cannot withdraw even a single penny out of the Consolidated Fund of India. But when it comes to Public Account of India, it is kept at the disposal of the government of the day. That means this Public Account of India is operated not through a legislative act, but through the executive action. But both these funds are constitutional funds. That means these two funds are mentioned in the Constitution under Article 266 of the Constitution. But so far as Contingency Fund of India is concerned, it is not a constitutional fund, it is a statutory fund. Now you might say, sir, Article 267 talks about Contingency Fund of India. No, Article 267 does talk about something called contingency, but it says Parliament can create a fund for contingency needs. And in the 1950s, Parliament of India enacted a law called Contingency Fund of India Act. And it is that act, it is that statute which created this fund called Contingency Fund of India, which is kept at the disposal of the President of India. And the Union Secretary of Finance takes control of this fund on behalf of the President of India. So long story short, Consolidated Fund of India, Public Account of India, these are constitutional funds. Consolidated Fund of India is operated through a legislative act, but Public Account of India is kept at the disposal of the executive. It is operated through the executive action. But so far as Contingency Fund of India is concerned, it is not a constitutional fund, it's a statutory fund created by a parliamentary law which is kept at the disposal of the President. And this fund is also operated through an executive action, which means to withdraw money from Contingency Fund of India, you don't need approval of the Parliament because it is kept at the disposal of the centre. It's kept at the disposal of the executive. Clear? Now let's look at another statement regarding National Human Rights Commission and select the correct answer. The year was 1993. A law was passed called Protection of Human Rights Act. And it is this law, this statute, this parliamentary law, which creates a statutory body called National Human Rights Commission. So National Human Rights Commission is a statutory body. And it is this law which was amended in the year 2019. That's what makes this a potential question for your examination, because there was some controversies surrounding NHRC as well. There is one judge, one former judge, Mr. Arun Mishra, who is the chairperson of National Human Rights Commission. He made some allegedly controversial remarks. We don't have to get into those controversies, but because of those controversies, the NHRC was in the news, that makes it a potential question for your prelims examination. Prior to 2019, and after 2019, when the law was amended, there has been a change. Prior to 2019, only an ex-Chief Justice of India could have been appointed as a chairperson. If you have been a Chief Justice of India, you are qualified to be appointed as the chairperson of National Human Rights Commission. Clear? You hold office till the age of 70, the chairperson of NHRC, and the term is 5 years. And you can be reappointed as well. Reappointed for another 5-year term. So prior to 2019, who could have been appointed as the chairperson of NHRC? Somebody who has been a Chief Justice of India. For how many years can you continue as the chairperson of NHRC? 5 years. Or till the age of 70. Can you be reappointed? Yes, for another term of 5 years. But after 2019, the law says that the chairperson of NHRC can be a former Chief Justice of India or a Supreme Court judge as well. That means not necessarily only the Chief Justice of India A former Chief Justice of India can be appointed as the chairperson of NHRC. Even a former judge of the Supreme Court can be appointed as the chairperson of NHRC. And now the term is 3 years or till the age of 70, whichever is earlier. That means now the term is only for 3 years. And at the same time, this chairperson can also be reappointed. But previously the law said you can be reappointed for another 5 years. But the law in 2019, when it was changed, it only talks about that a chairperson can be reappointed. But for how many years? That is not specified in the law. Can be reappointed as per the central government. This is the change. And it is in this backdrop that let's look at the question. Consider the following statements regarding the National Human Rights Commission and select the correct option. Only a former Chief Justice of the Supreme Court can be appointed as its chairman. This is wrong. Why? Because of this term only. Prior to 2019, this statement is correct. But after 2019, either this chairperson should be the former Chief Justice of India or a former judge of the Supreme Court. Mr. Arun Mishra, who was not the Chief Justice of India, he was the judge of the Supreme Court. And in one of his statements, he said, Prime Minister of India is a versatile genius. He is well respected throughout the world. And he gave a beautiful speech highlighting, praising the contribution of Mr. Modi, which is not wrong. But as the judge of a Supreme Court, you cannot be openly praising the member of the executive because there has to be some separation of powers between the executive and the judiciary. Or the judiciary should appear that it is independent of the executive. It does not come under the influence of the executive. That is why his statements, his speeches were deemed controversial, quote unquote. But Mr. Arun Mishra, he was not the Chief Justice of India, but he was a former judge of the Supreme Court. When the law was changed in 2019, then Mr. Arun Mishra was appointed as the chairperson of NHRC. Statement 2, the Act does not allow for the reappointment of members of the NHRC. It does allow, but it does not specify for how many years. So both these statements are incorrect. The question is asking which of the following statements are correct. D, neither 1 nor 2 is the right answer. Let's look at another question, and this is regarding the electoral bonds. But first, let's look at how many students do we have today with us. How many serious students do we have with us? Close to 1400. So if 1400 students are attending, can you please press the like button so that I can see you're awake, or are you sleepy? Those who are awake, press the like button so that I can get to know. That will keep me awake as well. Suddenly we are seeing students are waking up. My wish is more and more students should wake up. Yes, suddenly. Great. Electoral bonds as a topic has been in the news for a long time now, particularly because this matter is before the Supreme Court. And there is something called judicial evasion, where the judiciary is keeping some of the matters pending, not deciding upon these matters. And that is what we say, judiciary is evading judgments on these important matters. That's what we call judicial evasion. This judicial evasion can be a very important topic for your mains examination. But since electoral bonds have been in the news, many number of times the Supreme Court has allowed electoral bonds to continue without striking it down. That's what some activists plead for, because they say these electoral bonds, they violate free and fair elections, they violate the right to information, so on and so forth. So according to them, electoral bonds have no place in a democratic country such as India. Why? Let's say, for example, I have to donate money to a political party. There are various ways of donating this money, through cash, through check, anonymous donations as well. But there is always an element that cash should not be used to donate money to political parties because cash is viewed as black money or illicit money or unaccounted money. So now the target of the government was that we should only have clean money funding various political parties. Mr. Jaitley was the finance minister. Electoral bond scheme was conceptualized. Now, according to the scheme, if you want to donate money to a political party, you approach the State Bank of India and you buy an electoral bond. Value can be 1,000, 10,000, 1 lakh, 10 lakh, 1 crore. You can purchase as many electoral bonds as possible and donate to the political party of your choice. But you can buy these electoral bonds only through check or through digital transactions, which means through NEFT, RTGS, through other provisions. And then when this electoral bond is purchased, you can deposit this electoral bond in the bank account of your political party of your choice, and this political party has 15 days to encash this electoral bond. And if a political party is not encashing this electoral bond within 15 days, then it lapses. But this electoral bond is all anonymous. That means who is this donor donating this much money to a political party? You and me, we will never come to know. Because these are bearer bonds, these are anonymous bonds, and ultimately no one comes to know. This is where some activists, they claim that a right to information, so far as knowing the antecedents of political party and their candidates is concerned, it is a fundamental right under Article 19(1)(a) of the Constitution. Right to know about the candidates contesting election is a fundamental right of the citizens of this country. But here we will never get to know who is donating money to which political party and how much. That is why it is full of opacity, it lacks transparency, and that is why some people say it should be struck down. But Supreme Court has evaded judgments on electoral bond scheme for many times now, and final judgment has still not come. In fact, the former Chief Justice of India, Mr. Ranjan Gogoi, was asked, what about electoral bonds? Why have you not acted or decided the constitutionality of electoral bond? He said, I don't remember any such case pending before the court. But be that as it may, electoral bond scheme is in the news. Let's look at the question. Which of the following statements regarding electoral bonds is or are correct? Only recognized political parties can raise funds through electoral bonds. This statement is incorrect. Any political party, if it wishes to contest elections and seek some of the benefits that are given by Election Commission of India, it has to register with the Election Commission of India. And all these political parties which register with the Election Commission of India, we call them registered political parties. But over a period of time, some of these registered political parties, they are also recognized as either the state political party or national political party. And we have also seen in 2019, for the first time, a political party from Northeast called National People's Party, which is headed by Conrad Sagma, who is the Chief Minister of Meghalaya. It became the first Northeastern political party to become a national political party, to be recognized as a national political party. And electoral bonds can be purchased to donate to any political party if this political party has polled more than 1% of the valid votes. So any political party, whether it is recognized or it is a registered political party, any political party which has bagged not less than 1% of the total valid votes in the last election can be eligible to receive donations through electoral bonds. So this statement, only recognized political parties can raise funds through electoral bonds, it is incorrect, because any political party which has bagged not less than 1% votes is eligible to raise donations through electoral bonds. Statement 2, electoral bonds cannot be purchased multiple times by the same applicant. More often than not, 4 statements are given in a question. As an aspirant, you're sure about 1, 3, and 4, but you're not sure about whether the statement 2 is correct or incorrect. Then what do? You have never read the statement anywhere. And when aspirants feel that this statement is something we have never read, we have never come across, they assume that this statement can be wrong. Or they assume that this statement can be correct. But this is where common sense plays a very important role. Who makes laws? Political parties. The governments, parliament, can political parties make a law which is going to be against their interests? No, they will always keep their interest in mind. So if electoral bonds cannot be purchased multiple times by the same applicant, who is at a loss? Political party. So why would political parties do this? Which means you are saying Mr. Adani can donate only once, not more than once. Will a political party allow it? No. That means this statement also is incorrect. Electoral bonds cannot be purchased multiple times by the same applicant. It's incorrect because it can be purchased multiple times. Third, once the electoral bond is purchased, it cannot be cancelled and no amount will be refunded to the purchaser. This is correct. Because sometimes I have donated money to a political party. Now I want to cancel it. Political party will say, no, this money is going to come to us. We will never issue you a refund. So if this is allowed, it's going to be against a political party, which they will never want. So this statement is correct. Fourth, electoral bonds shall be valid for 15 days from the date of the issue. This statement is also correct. Statement 3 and 4 are correct. The question is asking which of the following statements are correct. 3 and 4 is the right answer. This is regarding electoral bonds. Let's look at another question. Which of the following is or are incorrect regarding the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act? This act, which was passed in 1980s, it was amended in 2015, then it was amended in the year 2018 as well. Why amended in 2018? Because there was a controversy. What was the controversy? Supreme Court had said that this law, which is famously known as the Atrocities Act, is liable to be misused, and it is misused by the members of SC and ST community. And to prevent the misuse of this law, what we will do, the Supreme Court directed that there should be anticipatory bail, and before arresting somebody, there should be a preliminary inquiry. Which means if I belong to SC or ST community, and there is another individual who belongs to non-SC, ST community, what if we have a tussle, we are involved in a brawl or a fight, I can get this non-SC, ST individual arrested under the Atrocities Act. He won't get any bail, he won't even get an anticipatory bail, and ultimately this process becomes a punishment for this individual. Now, to prevent the misuse or the alleged misuse of this law, the Supreme Court said this person is eligible for anticipatory bail, and at the same time, you cannot immediately arrest this individual. There has to be a preliminary inquiry conducted by the police, where the police should be satisfied that yes, there was an atrocity committed on the SC, ST member. Only once that preliminary inquiry by the police satisfies that yes, there has been an atrocity, only then this person can be arrested. And this judgment of the Supreme Court was viewed with skepticism by the members of the SC/ST community. They alleged that this judgment has basically diluted the very provisions of the SC/ST Atrocities Act. And this is where in 2018, this law was amended again by the Parliament. And this law basically tried to dilute the Supreme Court judgment. This law makes it clear that there is no anticipatory bail. There is no provision for an anticipatory bail. So Supreme Court said there should be anticipatory bail. Law says no, there can be no provision for an anticipatory bail. Supreme Court said preliminary inquiry is a must. The law said there is no need for a preliminary inquiry before filing of the FIR. That means basically this 2018 amendment, it tried to restore the original position of the SC/ST Atrocities Act, diluting the verdict of the Honorable Supreme Court. And this 2018 amendment was further challenged in the Supreme Court in a case known as Subhash Mahajan versus State of Maharashtra. This judgment was given in the year 2020. Supreme Court, what it did, it basically upheld these 2018 amendments, saying we don't have any issue with these amendments made by the Parliament, but in rarest of the rare cases, High Courts, they do have the power to give bail, but there is no anticipatory bail. So which of the following statements are incorrect? There is no provision for anticipatory bail for a person accused of atrocities against SCs and STs. This statement is correct. Preliminary inquiry is a must, and prior approval is required to file the FIRs in cases of atrocities. This statement is incorrect. So which of the statements are incorrect? Only two. B is the right answer. Now let's look at the Shah Faisal case. 2009-10 UPSC topper. He became the first person from Jammu and Kashmir to top the civil services examination. Then, after serving the government for a long time, for close to a decade, in 2018, he suddenly decides to resign. Resign against what he called the unabated killings of Kashmiris. Resigned, and then he wanted to start a political party. He started a political party. Then he gave speeches against the government's actions when the Parliament diluted Article 370, when the state was bifurcated. The allegation was that, in fact, one more important thing for your prelims exam is that he was on a study break, study leave, where he was studying at the Harvard University. And then when he was coming back, he started this political party, resigned from the bureaucracy, in fact, gave inflammatory speeches as well. The allegation is that he was about to travel via Turkey, Istanbul, to International Court of Justice to take up this case in the International Court of Justice at Hague. But then he was stopped at the Delhi International Airport, Indira Gandhi International Airport. He was brought to Kashmir, and then there he was booked under Public Safety Act. Amidst all of this, then he was released, then he was kept in a preventive detention. But suddenly he started speaking in favor of Mr. Modi, in favor of the government. There was a change of heart or change of mind, whatever it is. And now it seems that his resignation has not been accepted. He has withdrawn his resignation, and he is going to be brought back to bureaucracy. And some newspaper reports suggest that he is going to be brought on a central deputation. And we will look at central deputation as well, changing rules, because there is a conflict, or there was a conflict between the Chief Secretary of West Bengal and the central government. Didi's Chief Secretary and the central government. So all this becomes very important for your examination. And according to newspaper reports, Mr. Shah Faisal may be posted at the National Security Secretariat. Right or wrong? That we will leave it to the political class. Let's look at this issue. Can a member of bureaucracy, let's say IAS, IPS, Forest Service or Central Civil Services, can they resign? Yes. Resignation can be either you want to resign immediately, not just immediately, you can also resign at a future date. So you may resign today saying, I don't want to continue further, I want to resign immediately, or I'm submitting my resignation and this resignation should be accepted from this period, either immediately or at a future date. But this resignation has to be unequivocal, has to be unconditional. Unconditional in the sense, Mr. Shah Faisal could not have put this condition. This is my resignation, but there is a condition. If you can restore the special status of J&K back, I will take back my resignation. This is not how you resign. Your resignation has to be clear, unequivocal and unconditional. But this resignation is different from voluntary resignation scheme. Under this voluntary resignation scheme, if somebody is resigning voluntarily under a scheme of the government, these individuals are eligible for pension. So those who opt for voluntary retirement scheme, they're eligible for pension, but those who resign, they are ineligible for pension. Those who resign without opting for voluntary resignation scheme, retirement scheme, they are not eligible for pensionary benefits. But this resignation can also be withdrawn. So if I have resigned, I can also take back my resignation. But this resignation I have to take back before its acceptance. So if you have resigned, now the government has accepted this resignation. After that, you cannot withdraw your resignation because your resignation has already been accepted. But before the acceptance of your resignation, if you want to withdraw, you can withdraw your resignation. But this application calling for the withdrawal of your resignation may not be accepted. When it cannot be accepted? If you are withdrawing your resignation, but before you resigned, you wanted to start a political party. You wanted to join a political movement. If you had resigned because you wanted to start a political party, because you wanted to be part of a political movement, then the central government will not accept the withdrawal of your resignation. But how do you resign? If you are posted in a state, you resign by submitting your resignation to the Chief Secretary. If you are posted at the central level, central deputation, you can resign by submitting your resignation to the Secretary of that Union Ministry. That is how you resign. But then the central government may also accept the withdrawal of your resignation in public interest. And that is how it is viewed, that in larger public interest, Dr. Shah Faisal's resignation, withdrawal of resignation request has been accepted by the central government. So these are the rules concerning the resignation of a member of bureaucracy, IAS, IPS, Forest Service or Central Civil Services. If you want to resign, this resignation can be either immediately or at a future date. But this resignation has to be clear, unequivocal and unconditional. How do you resign? If you are posted in a state, you resign by submitting your resignation to the Chief Secretary. If you are posted at the central level, you resign by submitting your resignation to the Secretary of that particular ministry. But you can also withdraw your resignation. And you can withdraw your resignation only before it is accepted. After it is accepted, you cannot withdraw it. But the central government may not accept your withdrawal application if you had resigned to start a political party or to be part of a political movement. But then in larger public interest, the central government may also accept the withdrawal of your resignation. This is the case. And then there is another case. Central deputation. Can an IAS officer who is posted in a state, can he be posted at the central government level? Yes. That means these IAS officers, they are recruited by the center, they are trained by the center, but where do they work? They work in a state. And the central government may ask the state government, please give this officer either on central deputation or, very important for your prelims exam, we can post him to another state government, or we can post this IAS officer to any public sector undertaking as well. So what is the central deputation? The central government may ask the state government, please give us this officer because we want to post this officer to a central ministry, or we want to send him to a different state, or we want to send him to a public sector undertaking. But here this officer should be willing. Willingness of this officer is important. But what if officer is also willing, but the state government is not willing to let this officer go on a central deputation? So there is a conflict. So there is some disagreement between the state government and the central government. In this case, the rules say this direction of the central government is final. That means if there is a dispute between the central government and the state government vis-a-vis the central deputation of an IAS officer, this matter will be decided by the central government, and whatever central government decides will be binding on the state government, provided this officer is willing. But then the Chief Secretary of West Bengal, he had to participate in a meeting called by the Prime Minister. Prime Minister was visiting West Bengal. Chief Minister did not attend that meeting. And in fact, the Chief Secretary also did not attend that meeting. Why? Because Didi alleged that the leader of opposition of Legislative Assembly, who is my opponent, who defeated me in Nandigram Assembly constituency, Mr. Suvendu Adhikari, he's also part of that meeting. In what capacity is he part of the meeting? So I will not attend this meeting. And she, according to newspaper reports, directed the Chief Secretary that you should also not attend that meeting. The centre was furious. And this Chief Secretary, he was about to retire. But then he was given an extension that you will come on a central deputation for 3 months. And immediately, next day, the central government is issuing an order that this Chief Secretary will have to report to the central government. But the officer is not willing. When the officer is not willing, then how can you ask this officer to report to the central government? Instead, what the Chief Secretary did, he resigned. When he resigned, he was appointed as the advisor to Mamata Banerjee, to the Chief Minister of West Bengal. And in this backdrop, the rules regarding central deputation were changed. Or the proposal is to change these central deputation rules. According to these new rules, which are going to be implemented, according to these new rules, the centre will have to tell a state government that you have to keep a pool of officers ready for central deputation. Every year you have to mention the list of employees who are eligible or who are open for central deputation. And we can take this officer on a central deputation even without the officer being willing. That's one change. Second change is that if there is a dispute between the centre and the state government on the central deputation of this employee, of this officer, the original rule said that this matter will be decided by the central government. These rules make one more extra change. These rules say, in case there is a dispute, the matter will be decided by the central government within specified time. And the central government in these rules say, we can take any officer on central deputation in larger public interest. These are the three big changes which are sought to be brought about by the central government on this central deputation. That means in larger public interest, the centre may ask an employee, an officer to come on central deputation even if he is not willing. And if there is a dispute between the centre and state on this central deputation, then the decision given by the central government within a specified time will be final and binding. These are the changing rules on central deputation. Clear? Let's look at how many students do we have right now. We have again close to 1400 students. If you're all able to understand, again, press the like button so that I can know. Okay, this is one way of forcing you to like these videos. I have no other option to force you to like these videos. But be that as it may, let's look at another important amendment called Juvenile Justice Amendment 2021. The year was 2012. I think it was December 16, 2012. A horrific incident took place in Delhi. In a moving bus, Nirbhaya, a student who was out of to watch a movie with her friend. She was gang raped in a moving bus, and then she also died because of this incident. It was done in a horrific manner. In fact, her friend was also assaulted. He was also there in the hospital for some time, but unfortunately Nirbhaya passed away. One accused rapist, he was a juvenile. He was few months short of 18 years. So who is a juvenile? Somebody who is less than 18 years of age. There was a lot of hue and cry that this individual who is less than 18 years, if he is old enough to rape, he is old enough to hang as well. But since he was few months short of 18 years of age, he could not be tried as an adult. Because according to the law called Juvenile Justice Care and Protection Act 2000, this juvenile who is in conflict with the law, who has violated a law, he cannot be tried as an adult. If he has committed any crime, he can be sentenced, but maximum sentence that can be given to him is 3 years in jail. That too not in a regular jail, but in a reform home. And this rapist, who was few months short of 18 years of age, after spending 3 years in a reform home, he walked out free. But then in this backdrop, there was a lot of hue and cry, and people were demanding change in the law. And this is where Juvenile Justice, Care and Protection of Children Act 2015 was passed. And this Act of 2015 talked about 3 types of offences. Either the offences are petty, or the offences are serious, or the offences are heinous. Which are these petty offences? For which the punishment is less than 3 years. Which are the serious offences? For which the punishment is 3 to 5 years. Which are these heinous offences? For which the minimum punishment is 7 years in Indian Penal Code or in any other law. And this 2015 Juvenile Justice Act says, if there is a juvenile in the age group of 16 to 18 who is accused or guilty of committing a heinous crime, then what we will do? We will have a JJB, a Juvenile Justice Board. And this Juvenile Justice Board will now decide whether this person in the age group of 16 to 18 who has committed a heinous crime is crime where the minimum punishment under any law is 7 years. And now this Juvenile Justice Board will decide whether this person should be tried as adult or not. Previously, he could not be tried as an adult because the maximum punishment given for somebody who has come in conflict with the law is 3 years in a reform home. Now, if you are in the age group of 16 to 18 and you are in conflict with the law, you are accused of committing a heinous crime. Now, this Juvenile Justice Board will decide, looking at the psychological condition of this juvenile, whether he should be tried as an adult. And if he is decided that yes, he is psychologically, he is mentally an adult, even if not by age, then he can be tried as an adult. He can be sentenced to life imprisonment as well. He can be tried as an adult, but he cannot be given a death sentence. This Juvenile Justice Act of 2015 also talked about CARA, Central Adoption Authority. That means this law of 2015 also talks about adoption. And this law said that if you want to adopt a child, you have to come to this authority, and this authority will take the permission from the court, from a civil court. So civil court should give the adoption order, and based on that adoption order, you will now become the legal father or guardian of a child. Which means if there is a child who is to be adopted, the adoptive parents will approach the CARA, the authority, and they will approach the court. Once court gives the adoption order, then this parent will now become the legal parent of this child who has been adopted. It is in this backdrop that in the year 2022, two major changes were made to Juvenile Justice Act. Which are these changes? Change number one, instead of civil court, this decision to give an adoption order is given to district collector or also additional district collector. That means previously the civil court should have given the adoption order. Now this power to give an adoption order is given to a district collector or an additional district collector. And if you're not satisfied with this order, then you have to file an appeal before the divisional commissioner. And this divisional commissioner will have to act on your appeal within a period of 30 days. This is change number one. Change number one is instead of a civil court, now we will have the district collector or the additional district collector who will give this adoption order. And if you're not satisfied with this order, you can file an appeal before the office of the divisional commissioner, who will have to hear your appeal within a period of 30 days. This is change number one. Change number two. The Supreme Court in 2020 decided something. The Supreme Court said that if for any particular crime or for particular offense, no minimum jail limit is prescribed, or the minimum jail limit is less than 7 years, then such an offense cannot be a heinous offense. Based on the Supreme Court order, Juvenile Justice Amendment Act was passed in 2021. And now this Juvenile Justice Amendment Act says, serious offenses are those where no minimum jail term is prescribed or where the minimum imprisonment is less than 7 years, maximum punishment is more than 7 years. Even these offenses, they come under serious offenses. What is the difference? Previously, any crime for which the minimum punishment was 7 years, it was a heinous crime, and a juvenile who is accused of committing this heinous offense could have been tried as an adult. But now, more and more care is given to this juvenile. In a sense, more and more opportunities are given so that this juvenile is not tried as an adult. So that if he has committed any crime for which no minimum punishment is mentioned in the law, or the minimum punishment is less than 7 years, even if the maximum punishment is 7 years or above, then even then, this offense can only be declared as serious offense, which means this juvenile cannot be tried as an adult. Because juvenile can be tried as an adult only if the juvenile is accused of committing a heinous offense, for which the maximum punishment is 7 years now, or 7 years or more. If the minimum punishment is less than 7 years, it is not a heinous offense. That is what this Juvenile Justice Amendment 2021 is all about. Let's look at another question vis-a-vis the preamble. Which of the following statements is or are incorrect regarding the preamble of the Indian Constitution? Number one, the ideals of liberty, equality and fraternity have been taken from the French Revolution. Correct? The ideal of justice, social, economic and political, has been taken from the Russian Revolution. Yes, the ideals of liberty, equality and fraternity have been taken from the French Revolution. This is correct. The ideal of justice, whether it is socio, economic, political, has been taken from the Russian Revolution of 1917. So which of these statements are incorrect? None of the statements are incorrect. Both these statements are correct. Let me read this question again. Which of the following statements are incorrect? The ideals of liberty, equality, fraternity have been taken from the French Revolution. Correct. The ideal of justice, socio-economic, political has been taken from the Russian Revolution. Both these statements are correct, but the question is asking incorrect. None of these statements are incorrect. D is the right answer. Let's look at another question. Which of the following is or are incorrect? To change the name of any state, the Legislative Assembly of a state has no role. This is where some of you may get this question wrong. 2. Changing the name of railway stations is the prerogative of the Indian Railways. Which of these statements are incorrect? For that, let's look at Article 3 of the Constitution. Article 3 empowers the Parliament. That what Parliament can do? Parliament can pass a law, and through this law, Parliament can either merge 2 or more states, divide a state into 2 or more, increase the area of a state, decrease the area of a state, alter the boundaries of a state, including change the name of a state. And that's the power given to the Parliament under Article 3 of the Constitution. But even if the power is with the Parliament, states have a role. And that role is what we call a consultative role. And what is this consultative role? A bill under Article 3, a proposal to change the name of a state, for example, it cannot be introduced in the Parliament without the consent, without the previous consent of the President of India. But President, before he gives his consent so that this bill is tabled on the floor of the Parliament, the President necessarily will have to consult the legislature of that state which is going to be affected by this change. For example, you want to change the name of West Bengal. For that, the proposal will come from the state of West Bengal. West Bengal will ask, please change our name. Even if West Bengal does not ask, and the central government wants to change the name of West Bengal, they have to introduce a bill in the Parliament. But before this bill is to be introduced in the Parliament, you have to seek the prior consent of the President of India. And before President can give you the consent that you can table this bill, introduce this bill in the Parliament, the President will have to necessarily consult the legislature of that state which is going to be affected by this change. Which means the President will have to consult the legislature of West Bengal. It's only a consultative role, which means even if West Bengal says, no, we don't want to change our name, the President may still give his consent to the central government. You can now proceed with this bill. The bill will be passed by both houses of the Parliament by simple majority, and then this bill becomes an act, which means the name of a state can be changed. That means the statement to change the name of any state, the Legislative Assembly of a state has no role, is incorrect. Because they have a role, and that role is a consultative role. Although it is not a role where whatever they say is binding on the central government. No, but they have a role which is a consultative one. Statement 2, changing the name of railway station is the prerogative of Indian Railways. This is also incorrect. Which of the following statements are incorrect? 1 and 2. C, both are the right answer. Why? Few railway stations have been changed in the recent past. Last year, this year. For example, the Mughal Sarai railway station's name was changed to Pandit Deen Dayal Upadhyay railway station. In fact, Habibganj railway station in Madhya Pradesh recently was changed into Rani Kamlapati railway station. But who has the power to change the name of a state? This power to change the name of a railway station, this power is with the state government. Although this subject, railways, comes under union list, but it's the states who have a role. Because this proposal to change the name of a railway station has to come from the state government. And the state government will write to the central government. Ministry of Home Affairs is responsible for this. Ministry of Home Affairs gives its permission. Okay, the name of the railway station is not now Habibganj, it is going to be Rani Kamlapati railway station. But before this consent is given by the central government, they also keep, the Ministry of Home Affairs also keeps in loop the Ministry of Railways. But the Department of Railways, Indian Railways, they don't have any role. It is not the prerogative of Indian Railways to change the name of the railway stations. In fact, once the name change is allowed, then signboards are to be put up. Even when the Indian Railway is putting up a signboard replacing Habibganj with Rani Kamlapati railway station, even while putting the signboard, the Indian Railway has to seek the approval of the state government. That's very important for your examination. And in fact, the signboard has to be in 3 languages. Which language? A local language, English, as well as Hindi. But this does not apply to Tamil Nadu, where they use only 2 languages, Tamil and English. And this is where it becomes even more important for your examination, because in Karnataka also, we saw this issue where some people blackened the Hindi signboards of various railway stations. That is why it is in the news and it becomes a potential question for your prelims examination. So which of the following statements is or are incorrect? To change the name of any state, the Legislative Assembly of a state has no role. No, they have a role, although it's not a concurrent role, it's a consultative role. Changing the name of railway station is the prerogative of the Indian Railways. Wrong. Both these statements are incorrect. C is the right answer. Let's look at another question. Which of the following is incorrect regarding fundamental rights? All fundamental rights are exclusively enforceable against the state. Not all, there are some which are enforceable against private citizens as well. For example, we have Article 15, Clause 2 of the Constitution, which states no citizen shall be discriminated against only on the grounds of religion, race, caste, sex, place of birth. When this citizen wants to access public property, wants to access burial grounds, cremation grounds, bathing ghats, so on and so forth. Article 17, which is one of the absolute fundamental rights, which talks about untouchability is abolished. Untouchability is abolished and its practice in all its forms is forbidden. That's what Article 17 says. It's enforceable against private citizens as well, not only against the state. So all fundamental rights are exclusively enforceable against the state. This is incorrect. Supreme Court has exclusive jurisdiction to hear fundamental rights violation cases. Incorrect. What is the difference between exclusive jurisdiction and original jurisdiction? Original jurisdiction is one where you can file the case directly in the Supreme Court, not through an appeal, but directly. For example, you lost a case in the district court, you can file an appeal before the High Court. You lost a case in the High Court, you may file an appeal before the Supreme Court. So this case has reached Supreme Court through appeals. Appeals against the district court, against the High Court, and then it reached the Supreme Court. So this case was not originally directly filed in the Supreme Court. But what is the exclusive jurisdiction? Where the Supreme Court and Supreme Court alone can hear this case. Where the Supreme Court alone can decide a case which no other authority has the power to determine. For example, all federal cases, dispute between center and a state, dispute between 2 or more states and the center. This is a federal dispute, and these federal disputes can be only filed in the Supreme Court exclusively. No other court can hear these cases. Disputes involving the election of president and vice president. The Supreme Court has the exclusive jurisdiction to hear such cases because no other authority can hear or determine this case. But when it comes to fundamental rights violation cases, can you directly approach the Supreme Court? Yes. But can you only approach Supreme Court exclusively? No. You can approach Supreme Court under Article 32 of the Constitution, but you can also approach High Court under Article 226 of the Constitution. So disputes or violation of fundamental rights cases can be filed in the High Court as well. Yes, Supreme Court has original jurisdiction to hear fundamental rights related cases, because such cases you can directly file in the Supreme Court. But that doesn't mean Supreme Court has the exclusive jurisdiction to hear these cases, because high courts also can hear fundamental rights violation cases under Article 226. Third statement, all fundamental rights are self-executory. This statement is incorrect. Why incorrect? Because there are some fundamental rights which are self-executory. For example, they act on their own. They are implemented on their own without any need of a parliamentary law. For example, right to equality. You don't need to pass a law to say now we have equality. But then there are some fundamental rights which need to be executed through a law. For example, Article 23, which talks about prohibition of traffic in human beings. For that we have anti-trafficking laws. For that we have Prevention of Immoral Activities Act. These fundamental rights are not self-executory because you need a parliamentary law to implement them. So the question is asking which of the following statements are incorrect. Statement 1, all fundamental rights are exclusively enforceable against the state. This is incorrect. Supreme Court has original exclusive jurisdiction to hear fundamental rights violation cases. Incorrect. All fundamental rights are self-executory. Incorrect. All these statements are incorrect. So it should be D. All of the above is the right answer, because all these statements are incorrect. Let's look at another question. Which of the following statements regarding the 2016 child labor law is or are incorrect? Is or are correct? COVID-19 pandemic also led to a situation where various newspaper reports suggest that child labor is at its peak. You may have seen the NDTV campaign on child labor. This campaign was also there today in the news. Fantastic campaign, but this is in the news. Let's look at the question. According to Article 24 of the Constitution, there is a prohibition on child labor. Children less than the age of 14, they are prohibited to be involved in child labor. But till the year 2016, a child less than the age of 14 could not have worked in hazardous industries, but could have worked in non-hazardous industries. For example, as domestic worker, for example, in a roadside dhaba. The year was 2016, the child labor law was amended. And this child labor law said, child less than the age of 14 cannot be employed in either hazardous industries or non-hazardous industries, cannot be employed anywhere except in family business and in audio-visual entertainment industry. But specifically the law says excluding circus. So in 2016, when the law was changed, it said child less than the age of 14 cannot be employed anywhere, whether it is hazardous or non-hazardous, except the child can work after school hours or during vacation in their family business, or can work in audio-visual entertainment industry as child artists, movie stars, except in circus. And for the first time, this law talked about children in the age group of 14 to 18 who are known as adolescents. And these adolescents can work in non-hazardous industries, but these adolescents cannot work in hazardous industries. That's what this 2016 law talks about. Let's look at the question. The law allows adolescents to work in non-hazardous industries and occupations. This is correct, because only the child less than the age of 14 cannot work neither in hazardous nor in non-hazardous industries. But adolescents in the age group of 14 to 18 can work in non-hazardous industries. Prior to 2016, we had 83 industries in this list of hazardous industries and occupations. But Child Labour Law of 2016 reduced this number from 83 to only 3. And this law further says that even this number 3 can be further reduced. And for that, you don't have to seek the approval of the parliament. For that, the bureaucracy, for that the officers of the central government may change the rules on their own and reduce the number of hazardous occupations and industries from 3 to 2 to 1 to 0. That means parliamentary approval is not required. That's what the second statement says. The number of hazardous industries can be reduced only by the parliament. This is incorrect, because the hazardous industries under child labour law can be reduced by the executive, can be reduced by the bureaucracy. Parliamentary approval is not required. Slightly difficult question, but the question is asking which of the following statements are correct. It is A, only one is the right answer. Let's look at another question. Which of the following statements is or are correct? Right to marry is a fundamental right. On marriages, there are lots of controversies. Unfortunate death of an individual who was killed by the relatives of his wife. They belong to different faiths, and the relatives of the lady, they did not like their daughter or their sister to marry to a person belonging to a different faith, and he was brutally killed. Despite the fact that right to marry is a fundamental right under Article 21 of the Constitution. So right to marry is a fundamental right. This is correct. Constitution protects all the rituals, customs of a religion which are essential to it. This can be slightly tricky for you, and let me explain. Resham versus State of Karnataka. This case is famously known as the hijab case. The school authorities, the college authorities in Karnataka decides to ban hijab when you're entering the college, when you're taking the tests. This was challenged by the students, saying right to wear hijab is my fundamental right, because Article 25 gives me the fundamental right to profess, practice and propagate your religion. And I want to practice my religion by wearing hijab. And right to wear hijab is my fundamental right. Then the Supreme Court had to decide, or the court had to decide, in this case the Karnataka High Court had to decide whether wearing a hijab is essential to Islam or not. Because the year was 1954, when in Shurur Mutt case, the Supreme Court said and invented a doctrine called Doctrine of Essentiality. According to this doctrine, which is also known as Essential Religious Practices Test. According to this doctrine, the judiciary will have the power to decide what is essential to a religion, what is not essential to a religion. If there are some features which are essential to a religion, some rituals which are essential to a religion, they will get protection. But those features which are not essential to a religion, that the court will decide what is essential, what is not essential. And those non-essential features will not be protected by the court, will not be protected by the Constitution. And the Karnataka High Court said wearing a hijab is not an essential feature of Islam. That is why there can be hijab ban in Karnataka. But the statement is saying Constitution protects all the rituals, customs of a religion which are essential to it. This is actually a correct statement. Because although it is the Supreme Court which gets to decide what is essential to a religion, what is not essential to a religion. But Supreme Court gets to decide based on the Constitution. Because Supreme Court is the final interpreter of the Constitution. Likewise, is right to privacy mentioned in the Constitution? No. But can we say right to privacy is protected by the Constitution? Yes. Because the Supreme Court's interpretation in 2017, K.S. Puttaswamy judgment is right to privacy is a fundamental right. So right to privacy is protected by the Constitution. Supreme Court said right to marry is a fundamental right. So right to marry is protected by the Constitution. Supreme Court in Shurur Mutt case talked about essential religious practices. That means the Constitution will protect some of the essential features, Constitution will not protect non-essential features. Which means Constitution is going to protect rituals and customs of a religion which are essential to it. So this statement is right. The question is asking which of the statements are correct? Both 1 and 2 are the right answer. Let's look at another question. Which of the following statements is or are incorrect regarding the directive principles of state policy? You read this question, I will check how many students are with us. Let me know what is the answer to this question. The definition of state is same as followed in case of fundamental rights. Correct? Because Article 12 and Article 36 are the same, which talk about definition of the state. The principles are not enforceable in a court of law as these are inferior to fundamental rights. Directive principles are not enforceable in a court of law, but that is not because directive principles are inferior to fundamental rights. They're not enforceable in a court of law because to implement these DPSPs, the state needs time and resources, not because they are inferior. To promote international peace and security is explicitly mentioned as one directive principle. Correct? Under Article 51 of the Constitution, to promote international peace and security is one of the directive principles. And this becomes important in the backdrop of Ukraine-Russia controversy, where the Prime Minister Modi and the central government, they justified their take on Russia-Ukraine on the ground saying that we encourage peaceful settlement of all disputes because that is something which our Constitution mandates under directive principles of state policy. Statement 4, to develop Hindi is a directive principle under Part 4 of the Constitution. Yes, to promote and develop Hindi is a duty on the central government so that Hindi can become a medium of instruction for all the elements of the composite culture. It's a directive, but it's a directive outside of Part 4 under Article 351 of the Constitution. This is not something which is mentioned in Part 4, so it is not part of the directive principles of state policy. So this is incorrect. The question is asking which of the following statements are incorrect. 2 and 4, A is the right answer. Let's look at another question. Which of the following needs a constitutional amendment? If you want to make these changes to the Constitution, which of these need a constitutional amendment? If you want to continue the use of English in the Parliament beyond a period of 15 years, it does not need a constitutional amendment. If you want to delimit constituencies, that is done by an act. For that, you don't have to amend the Constitution. If you want to make any changes to 5th and 6th schedule of the Constitution, you don't need a constitutional amendment. You can do this through an ordinary law passed by simple majority. Quorum in the Parliament, which means how many members should be present in the Parliament so that Parliament can function, which is considered to be 1/10 of the strength of Lok Sabha, 1/10 of the strength of Rajya Sabha. If you want to change this number, quorum, for that you don't need to amend the Constitution. So which of the following needs a constitutional amendment? D. None of the above is the right answer. Question, which of the following is or are declared by the Supreme Court in the Minerva Mills case as part of the basic structure of the Constitution? So the doctrine of basic structure was invented by the Supreme Court in a landmark Keshavananda Bharti versus State of Kerala on 24th of April 1973. But then we have another landmark case called Minerva Mills case. It also expanded the scope or the list of basic structure. Supreme Court in this Minerva Mills case said judicial review is part of the basic structure of Indian Constitution. It was in the same judgment that Supreme Court said harmonious relationship between directive principles and fundamental rights is also part of the basic structure. But the supremacy of the Constitution, it was declared as the part of the basic structure in the Keshav Ananda Bharti judgment, not in the Minerva Mills case. So 1 and 2, C is the right answer. Let's look at Dam Safety Act, against this law there is a protest by the Tamil Nadu state government. This is a law which talks about surveillance, inspection, operation, and maintenance of dams, so that we prevent the disasters. And this is a law which talks about that there should be uniform rules throughout the country for the surveillance, inspection, operation, and maintenance of these dams, so that we prevent the disasters due to the operation of these dams. And it is this law which talks about dams mostly above 15 meters, but dams between 10 to 15 meters are also covered. And it is this Dam Safety Act of 2021 which basically talks about that we should inspect these dams before the onset of monsoon, even after the onset of monsoon, so that we can fix the responsibility, so that those who operate these dams, those who have constructed these dams, they are able to maintain these dams so that we don't have the disasters during the natural disasters. It doesn't cause havoc because of the mishandling of these dams. In India, the dams are constructed mostly by the states, but there are some dams which are operated by some autonomous bodies. For example, we have Damodar Valley Corporation, Bakra Bias Management Board. So most of the dams are constructed in the states, operated by the states, constructed by the states, some by private players as well, some by autonomous bodies such as Damodar Valley Corporation, Bakra Bias Management Board. But at the same time, these dams, how can Parliament make a law? Because when we look at Constitution, it talks about water being under state list. It talks about water storage is also part of the state list. So how can Parliament pass this law on Dam Safety Act? Because these dams are used for water storage, so that this water can be used for electricity generation, this water can be used for irrigation facilities. In fact, in 2010, a dam safety bill was introduced in the Parliament, that too under Article 252. And what is Article 252? When two or more states request the Parliament, then Parliament is empowered to make a law on state list. And in the year 2010, I think it was West Bengal and some other state, West Bengal or some other state, whether it was Andhra or some other state, which had requested the Parliament to pass a law on these dams under Article 252 of the Constitution. But the government is justifying this Dam Safety Act on the grounds saying that there are some dams which work interstate. Mulla Periyar Dam, for example, constructed in Kerala, but used to provide water to irrigate the lands of Tamil Nadu. There are some dams which are used by multiple states. So that is why it becomes empowering for us. It becomes a part of our rights, parliamentary right, to form a law, because interstate river water or interstate usage of river is within the domain of the parliament. But some people are criticizing this law on the ground, saying that there is no fixing of compensation. The law is silent as to who will pay the compensation in case there is a dam failure. So that is one aspect of the law on which it is criticized. But again, important point for your prelims examination is that it creates two national bodies. One is the National Committee on Dam Safety, and the other is National Dam Safety Authority. The function of this committee consists of the chairperson of Central Water Commission. It has 10 members nominated by the central government, at least maximum of 7 members nominated by the state government. So basically the role of this National Committee on Dam Safety is to create rules, regulations for dam safety, and these rules and regulations are to be implemented by this National Dam Safety Authority. And it is this National Dam Safety Authority which is also going to resolve the disputes between the states. And please remember, we are not talking about interstate river water disputes. We are only talking about dams. Those dams which are above 15 meters, or some of the dams between 10 to 15 meters, they come under the ambit of Dam Safety Act 2021. The purpose is that there should be uniform rules across different states on dam safety so that we prevent disasters. So surveillance, maintenance, operation, inspection of these dams, we will have uniform rules throughout the country. And this Dam Safety Act creates two bodies at the national level: National Committee on Dam Safety and the National Dam Safety Authority. Conceptualizing rules and regulations on dam safety is the job of this committee. But to implement these rules, we have another authority. And this authority will resolve the disputes between states as well. But the silence of this law on the compensation to be paid when there is a dam failure, that is considered to be one of the criticisms of this law. And at the same time, if water is a state subject, if water storage is a state subject, then how can Parliament enact this law? That is why Tamil Nadu state and other states, they are protesting against this law. But this is something which is important and relevant for your prelims examination. We have another topic, although we have crossed 9:30, which is the stipulated time. But if you want, I can continue for another 5 to 10 minutes, and then we can finish off this topic as well, so that we don't miss out on anything. Should we continue? If yes, you will have to press the like button. That is how I can get to know whether you want me to continue or you want me to just stop. Okay, I'll still continue. Delimitation is the ordering of the constituencies, the reorganization of the constituencies or the elected constituencies, that to ensure one person gets one vote. Constitution says originally that after every census, there should be reorganization of the constituencies' territorial boundaries. That means after every census of 10 years, we should have a delimitation. This delimitation exercise was conducted in 1952, 1963, 1973, then again in 2002. And every time this delimitation exercise was carried out here, it led to the increase in the number of seats. And it was in 1973 delimitation exercise that some of the southern states went to the Prime Minister and basically pleaded that even if delimitation exercise is carried out, it should not lead to the increase of seats. Because one of the factors on which delimitation exercise is carried out is the population. If the population is increasing, more seats will be allocated. Southern states who were fairly successful in implementing the family planning programs, they protested and said that we are at a disadvantage. The northern states have not implemented the family planning programs effectively. So their population is increasing, and corresponding to the increase in the population, they will get more and more representation in Lok Sabha. So the southern states will be at a disadvantage. This is where Indira Gandhi was the Prime Minister. 42nd Constitutional Amendment Act was passed in 1976, and it said there will be no delimitation till 2001. So unless and until 2001 census is carried out, we will not have any delimitation. Even if delimitation is conducted after 2001, we won't see the increase in the number of seats. The seats will be frozen till 2026. But then the delimitation exercise was carried out in 2002, and this delimitation exercise continued till 2008, but even then it did not lead to the increase of the number of seats. Then for what purpose was this delimitation conducted in 2002? This is what we call internal delimitation. And I'll give you one small example. Let's say we have a state which have 3 constituencies, 1, 2, 3, and the total population of the state is 30 million, for example. But in constituency 1, we have only 5 million voters or population. In constituency 2, we have 25 million population, and in constituency 3, or let's say 24 million, and in constituency 3, we have only 1 million population. It violates one person, one vote. Because here 5 million people are represented by 1 MP. Here 24 million people are represented by 1 MP. And here 1 million people are represented by 1 MP. So this internal delimitation was carried out so that we can divide the state into 3 constituencies, so that in all the 3 constituencies we will have 10 million population each. That is what we call internal delimitation. This was purpose number 1. And purpose number 2 was to provide for increased representation for the members belonging to SC and ST community. But this delimitation exercise was not conducted in 4 states. Which were these 4 states? Assam, Manipur, Nagaland, and Arunachal Pradesh. And it was not also carried out in Jammu and Kashmir. Why? Because Jammu and Kashmir had its special status. They had their own rules of carrying out delimitation. This delimitation exercise was not carried out in these 4 states because these 4 states had protested, saying we don't want 2001 census to be the basis for reorganization or delimitation. And ultimately, President said, okay, delimitation exercise will not be carried out in Assam, Manipur, Nagaland, or Arunachal Pradesh. And when it was not carried out in Jammu and Kashmir as well, then in 2019, when Jammu and Kashmir was reorganized, Jammu and Kashmir Reorganization Act also called for increase in the number of seats to Jammu and Kashmir, for which delimitation was required. And that is why a delimitation commission was set up. And this delimitation commission was tasked that you conduct delimitation exercise in Jammu and Kashmir as well as in these 4 states where last time delimitation was not carried out. But then, this is where it becomes important for your prelims exam. But then somebody flagged an issue saying delimitation commission cannot conduct delimitation exercise in these 4 states. Why? Because in these 4 states, you have mentioned previously in a law that in these 4 states, Election Commission of India will have to carry out delimitation, not the Delimitation Commission. So in 2008, when Delimitation Commission, which was set up for 2002 delimitation exercise, when this Delimitation Commission was not allowed to continue with delimitation exercise for Assam, Manipur, Nagaland or Arunachal. The law said in these 4 states, it is the Election Commission of India which will conduct delimitation exercise. But in 2019, when delimitation commission was sought to be set up for these 5 states, somebody flagged an issue, wrote to the Election Commission as well as to the Law Ministry saying this is unconstitutional because the power to conduct delimitation in these 4 states we have given to Election Commission of India, not to Delimitation Commission. That is why in these 4 states, delimitation was stopped and delimitation was conducted only for this Union Territory of Jammu and Kashmir. And for Jammu and Kashmir, for the first time perhaps, the basic criteria of population was not used. Apart from population, what was used as a criteria for delimitation was border area, remoteness of an area, backwardness of an area. These criteria along with population was used to determine which area will get how many seats. And that is how Delimitation Commission recommended a total increase of 6 seats to Jammu province and 1 seat to Kashmir province, despite the fact that Kashmir has more population than Jammu. But since population alone was not the criteria used by Delimitation Commission, they used another criteria such as the closeness to the border, the difficulty of terrain, hilly areas. These conditions were used. Another important thing for your prelims is that the award of the Delimitation Commission cannot be challenged in any court of law. So if there is a question in your prelims examination regarding delimitation, number 1, delimitation necessarily is not only conducted by or carried by the Delimitation Commission. Election Commission of India also has the power of delimitation vis-a-vis these states. Population is not the only criteria to carry out delimitation. Delimitation was carried out in 1952, 1963, 1973 and then in 2002 as well. And delimitation award, once it is published, cannot be challenged in any court of law. That is it from us for today. Thank you for being with us. I hope I was able to resolve some of your queries, some of your doubts. I hope you have enjoyed these 4 sessions because I clearly have enjoyed all of them. And you can see that on my face. Thoroughly enjoyed these sessions. And if you have also enjoyed these sessions, please press the like button, comment under these videos. That's the only way I get to know whether you have liked these sessions or not, and whether my hard work has really paid off or not. Otherwise, we don't know each other. So how would I know whether you have liked these sessions or not? So let me know. Press the like button, comment once the video is over, subscribe to our channel if you haven't yet, share the links of these classes with your friends and fellow aspirants. This was the last lecture on Indian polity in the series Target Prelims 2022. But as I told you, Target Prelims 2022 continues. Next 2 lectures on government schemes and programs, followed by 3 back-to-back sessions on environment and ecology, then 2 sessions on Indian economy, the remaining 2 sessions, lecture 3 and lecture 4. Then we'll have 3 back-to-back sessions on science and technology. Then we'll have 1 special lecture on various reports and the indices, followed by 2 last lectures on international relations. That is it from me. Hope to see you soon. Some of the very, very important initiatives that we are going to come up with, all for the benefit of the student community, for the civil services aspirants. All the best. Bye-bye. Take care. Stay safe. All the best for your exams. Thank you. Good evening.